So, thank you very much. Yes, indeed. You've seen the buildings now. You should learn and know how it works with the UPC. And again, I'm more the guy not looking into the future rather than to the past. So, in order to understand what the UPC is about, I think it's a good start to look to the past. So, to the time before the UPC agreement entered into force, which was on 1st June of this year. So how was the situation like before? With regard to the European patent system. So at the beginning, so let's say in the early 70s, you could only go for national patents. So you had the national patent in France, in Germany, in the UK, and then of course you could also enforce only the national patents. It was very much different from the situation in the US. We had a big market, one patent, one court for all of the country. And how it's now also in the other big markets like China, like Japan, like Korea, Brazil, India, and so on. Okay, now the first step to create a European patent system was to setting up the European Patent Office on the basis of the European Patent Convention. That's an international treaty. And it currently has 38 contracting states, including all, that's a typo, sorry about this, 27 EU member states. I'm sorry, we lost one. And 10 or 11 other non-EU states. And the beauty about the European Patent Office is you just go to one shop, one-stop shop only, and in one proceeding you get one patent that gives you protection for all of Europe. 38 states in one office. However, once it has been granted, it splits up into a bundle of patents. So the effect of the European patent is not a unitary patent. It is in each of the contracting member states of the EPC like a national patent. So in France, it is the French part of the European patent has the effect like a French patent. It's in Germany, the German part of the European patent has the effect like a German patent, and so on and so on. And this, of course, also means a lot of costs, a lot of money to be paid when you want to have protection in all these states, because you have to validate the patent, you may be required to submit a translation of the patent in the respective language, and of course you have, each year you have to pay fees in all, if you want to have protection in all 38 member states, you have to pay fees 38 times in parallel. And it takes a patent attorney who takes care of this, and so on and so on. Okay, so that's about the European patent. Now, when it comes to enforcement of a European patent, essentially you have to enforce it state by state. So, and that is on the basis of on the Brussels recast regulation. The Brussels regulation, you know, it's about international jurisdiction in the EU. And it essentially says, okay, you can have in patent infringement cases, you can have, the court can have jurisdiction when the place of the infringement is in a particular state. But this again goes state by state. So for the French part, infringement in France, you go to a French court. For the German part of the patent, infringement in Germany, you go to the German part. And you have to go parallel, while the product is sold all over Europe. However, there's of course also Article 4, paragraph 1 of the Brussels recast, that says, okay, you can sue at the defendant's seat or domicile. Okay, that you can do, but this requires that the defendant has a seat in one of the EU member states. Let's say it's in Germany, yes, then you can sue the German company for all the infringements in all of the EU. But I come to a point that it, in just a second, that it very often will not work like this. The same is true when you have a number of defendants and the claims are closely connected, then you can even bring against a number of defendants. So let's say they are connected, a group of companies. You may, under certain conditions, bring it to one court with regard to infringement. But then, what about validity? So when a revocation action is brought by the defendant, a revocation action again goes always country by country. So when you bring a revocation action, you have to bring it against the French part before the French court, against the German part against the before the German court. And that means that then the infringement action you may have brought against the German company with regard to infringements in a number of countries, that court will either has no jurisdiction at all anymore once the revocation cases have been brought, or at least that court will have to stay proceedings and wait for the outcome of the revocation action. That question whether the infringement court in that situation would no longer have jurisdiction or would have only to stay is an open question that's currently pending before the European Court of Justice based on a referral by a Swedish court. Okay, anyway, it is no good. You have, in principle, you always have to go country by country. There is also exception with regard to preliminary injunction proceedings, but still, in principle, you have to go country by country. And that, of course, is a problem when you have to, you pay for infringement cases in parallel in Germany, in France, and so on. Okay, on that background, the idea came up, okay, not only on the prosecution side, so on the granting side, you need one stop shop only, but also on the enforcement side. And that's why 17 contracting member states set up the agreement on the UPC, which came into force on 1st of June. Now the idea is the UPC is a common court of several member states, so of the contracting member states. And it steps in where before the case before the national court had jurisdiction. So when it's about the infringement of a European patent, German part, it was the German courts who had jurisdiction. Now it is the UPC who steps in. And the same with regard to France, and I could now count all the 17 contracting member states. So the UPC essentially is a court, a German court, a French court, a Latvian court, a Lithuanian court, a Swedish court, and so on and so on. So that's essentially the idea. Now, there is, now when you boil it down under the Brussels recast, you see the following. Okay, place of infringement again. And it applies to such a court that by an amendment of the Brussels regulation, Article 7, paragraph 2 is applicable. But now, since this is a court of France, of Germany, of Latvia, you can bring all the three infringements in one court. And when the defendant has its domicile, the same applies. The court, wherever when the claim, the defendant has its domicile or seat in one of the contracting member states, then you can bring the claim there. And the same for the number of defendants. And now that's again also with regard to validity, revocation. Since the German court is considered to be a German court, they can decide on the validity of the German part. At the same time, they can consider, they can decide on the French part and on the Latvian part, and so on. Okay, that's in principle. Now, there is a transitional period in the first 7 years. So what does the transitional period mean? Okay, you have to understand, well, European patents are out there now for almost 50 years. So there are existing European patents, and there may be patent owners who don't have confidence in the system, so in the new system, the UPC system. So that is why the agreement allowed these owners and also applicants for a European patent after patent application has been disclosed, so has been published, that they can opt out the patent. For those who opt out, the situation like I described or how the situation was before 1st of June applies. So they're simply out there. The old system for them applies as well. For those who stay in, who did not opt out, they can choose for the bundle patents where to bring the claim. So they can bring it to the UPC, but in parallel they can also bring it before the national court still during that transitional period. So opt-outs, roughly, there were about 1.5 million roughly out in the air, European patents, European patent applications that could have been opted out, and in practice, a third has been opted out. So 2/3 are in. And now there's also, I explained to you, it's a bit problem with the European patent, it's a bundle patent. And a patent owner has to pay to validate the patent in each of the contracting member states of the European Patent Convention. And they have to pay each time a renewal fee, they have to pay for translation, etc. Now the idea is there not only to have a new court, but also have a unitary patent. And the beauty of the unitary patent is that you get patent protection in 17 contracting member states, but you pay about a renewal fee that is somewhere between 3 or 4 contracting member states on average. So it's a bargain, at least for those who validate the patent in more than 3 to 4 contracting member states. So it's also attractive, and we currently already have, well, we started on 1st of June, and we currently already have I think between 6,000 and 7,000 unitary patents to be granted. And the unitary patent, they give protection in the contracting member states, the 17 states, but remember it were 38 states that are member states of the European Patent Convention. So in parallel, of course, you can still have, you have the unitary patent protection in the 17 contracting member states, but you can have in parallel, of course, still have the protection in the UK, for the UK of the European patent, and for the Spanish part of the European patent, you can have it in Spain in parallel. So it's a bundle, it's a one big part of the bundle, and then the old individual parts of the bundle as well in parallel. So that's how it works essentially. Now you see the structure of the court. You see the Court of First Instance, which essentially has a local, has a number of local divisions. It has one regional division at the moment, can have more in the future, but at the moment only one, and has a local division. And it also has, of course, a Court of Appeal located in Luxembourg. And both instances are either, they are allowed to make referrals to the European Court of Justice, or they are obliged to make referrals to the European Court of Justice, like in the national systems. In the national systems, if you are a lower court, you have discretion whether you make a referral to the European Court of Justice. It's not mandatory for you. While when you are at the top end, so last instance, then, and there's an issue of European, of Union law, EU law, that is not clear and has not been clarified by a decision of the European Court of Justice, and matters for you to decide the case, you have to make a referral, and that is true also for the Court of Appeal of the UPC, because that's the last instance in the system. So essentially the same law applies to the UPC with regard to obligations to make a referral to the CJU, like in each of the national states. And then there's also a patent and arbitration center, which has not been set up for now, but it's provided for in the agreement, and is going to materialize in the future, in the near future. Okay, here you see now the full picture of Europe. You see different blues. So the dark blues, that are the contracting member states. You see the little lighter blues. These are the member states that have signed the agreement, but have not yet ratified. And if you ask me who is going to be, what my guess, who is going to be the next to ratify from those who have signed, I would think it would be Ireland. At least they are planning to have a referendum on this. They don't want to have a referendum only on this issue, so they're either waiting to make a bundle of referenda, issues for a referendum, and then have it in one go, because it's also a financial issue, or have it combined with the next election for the European Parliament. So that's the next year. Okay, and then we have the very bright blue, these are those states that neither have signed nor ratified, and this particular two big economies, Spain and Poland. But after all, when you only look at the contracting member states, the 17 states, and you look at to the gross national product of the EU, it covers 3/4. So you have a big market already now with the 17. It's a big market. So, and that's, I come back to the idea to have one patent for one big market also in Europe. So that somehow gets Europe to the same standard as you have it in the US, as you have it in India, as you have it in China. Yeah, and below you see the different locations, and particularly, of course, the regional division in Stockholm, but also they can hear cases in the 3 capitals of the 3 Baltic states. So they can also have a hearing in Riga. Okay, these is the competence. So essentially, it's about infringement of European patents and revocation, but also preliminary measures. So I'm not going too deeply into this. Well, what is the composition of the panels that are going to decide? The probably most interesting aspect is not the legally qualified judges. Well, it's always legally qualified judges, but they are joined by technically qualified judges. And in the central division, it's a composition of 2 legally and 1 technically qualified judges, of course, always from the technology of the case. And in the local division, it's 3 legally qualified judges, but most of the time they will be joined by a technically qualified judge. And the Court of Appeal level is 3 legally and 2 technically qualified judges. Maybe one, sorry, now I have to go back to this. Yeah, technically qualified judge, where do they come from? There are some member states that already have technically qualified judges like Sweden or Germany, so you can take it from their ranks. Sometimes it's also taken from the ranks of patent offices. It's not taken from the European Patent Office because that's excluded. That's what the legislator didn't want to happen. But it can also be from private practice, so it can be also patent attorneys. And then there was quite a discussion about whether these there might be a conflict of interest, and we have a code of conduct has been set up. And this provides that when you are a patent attorney and you are at the same time a technically qualified judge, you are not allowed under the Code of Conduct to represent cases before the UPC. You may represent still cases before the national courts, yes, but not before the UPC. Languages. Well, Europe has a multitude of languages, and of course that doesn't make things easier. Essentially, it is the official language of the contracting member states that is hosting a local division. That is the language of proceeding. But member states hosting a local division could alternatively determine one of the 3 languages of the EPO official languages as an alternative language of proceedings. And that is what all contracting member states hosting a local division did. So, for example, in Germany, claimant can choose between German or English. France, astonishingly, but it's the case, it's the same. You can now sue in France, on the French territory in English, if you want. And same for Italy, for all contracting member states. And then we have the regional division that took a very wise decision that they said, okay, it should not be one of the 4 languages of those contracting member states, including Latvia, that are sharing this division, but we only want to have English. And so it is, for the regional division, it's only English, which makes things, of course, much easier. Now, what about procedure? Well, it is essentially, I guess, the same like in Latvia. So there's a written procedure. Everything parties relying on has to be submitted in the written procedure. It's not a skeleton procedure like you can see sometimes or most of the time in the UK. That's, I think, the main difference. And there's also strict deadlines. But at the moment, since there's some problems with the CMS, judges are much more generous in order to compensate for that. Then there's an interim procedure. The idea of the interim procedure is twofold. The first one is to prepare, to do everything necessary in order to prepare the oral hearing. So summoning witnesses, experts if necessary, or all these kind of things, and clarify certain facts, whatever. And secondly, to find out whether a settlement is possible. So if a settlement is not possible, then it will end in an oral proceeding and in an oral hearing, and that works essentially like the same as you are used to it. So I don't go too much into details. Well, it should be endeavored to do it in one day. Of course, if the needs of the case are a very complex case, you can also may have two hearing dates. For example, the first hearing actually that took place, there's already one hearing in the preliminary injunction case that took place in Munich just a few days ago. They, just to be on the safe side, they had provided 2 days, but they did it in one. But then, if the case would have been longer, they could have had also a second day, and all the rooms, everything be prepared. The hearings can be done in video conference, but only in exceptional cases as a whole. What, however, is possible is that the hearing takes place in the respective local or whatever division, and but the court allows parties or representatives to join from remote. That is always possible, but it needs the permission of the court. Then public access to the register, that's also interesting. You can go to the UPC website, and when you have access to the register, you have to identify yourself. But when you have access to the register, then what you can see, okay, submission of the statement of claim, submission of the statement of defense, etc. But you do not have access to the content of these statements. If you want to have this, you have to make file a particular application, and then the judge will decide on this application. And if the judge decides yes, you have access to this, then before allowing access, that is a bit complicated, and then the file has to be checked under GDPR principles. So essentially make sure that names of natural persons will be blackened, etc. That's a bit a challenge, but we're currently identifying software to do the job. Because the difference is normally you have this requirement with the CJU only for decisions issued by the court, orders and decisions. That's a rather easy job. But when you also have to make access to a file, so include all the submissions and all that has been attached to it, GDPR compliant, then of course, well, either you get thousands of clerks on board, or you do it by software. That's a third alternative is not, at least I don't see such a third alternative. Okay, protection of confidential information, that's available. Confidentiality in one aspect with regard to third parties, with regard to the public, of course, but also between parties. So this is along the lines of the trade secret regulation that is essentially has been implemented in the UPC system. So there can be confidentiality clubs, in particular when we speak about SEP cases, and it is about comparing licenses, and in the licenses there are a requirement that it should not be open, disclosed to anybody. That may be a case for such orders for a confidentiality club. Pre-trial procedures. Well, it is along the lines of the enforcement directive. It is not what is known from the US pre-trial discovery, US style. That's not going to happen. Like it is not going to happen anywhere else in Europe. Experts, well, party experts are possible. I do not expect many court-appointed experts in the system. Well, after all, there are technically qualified judges on the panel, on the bench. Okay, permanent injunction, that's again the discussion we already had with the proportionality issue, and award of damages also goes along the lines of the enforcement directive. Yes, and this is an interesting aspect, uniform, the court calls itself a unified patent court. Now, when you look at judgments from France, you see the reasoning, and then you see the operative part, so the final order. When you look at judgment from Germany, you see the operational part at the beginning, and then you see the reasons. Okay, it's a bit like having traffic on the left side or on the right side of the street. And so you have to make a decision. It can't be that in the local division in France, they do it like they do it in the national courts in France, and in Germany, they do it like the national courts in Germany. And it's not only about this issue, it's more things that are involved. So a uniform format is needed. And for that purpose, there was already an expert group working on this, starting the work, I think, 2 years before the coming into force. And there was set up a number of guidances and templates to deal with this. And then the decision was taken, okay, that the UPC, the operative parties, will be at the end of the decision. So judges, but also lawyers, representatives of parties are invited to look into the guidances and see what the format should be. Also, for example, with regard to orders that are going to be issued, because when we speak of injunctive relief, that can be drafted in a very different way. It can be stop using the patent, or it could also be stop using, and then you have all the wording of the patent claim followed, and all what is understood by use could mentioned, so production, marketing, import, etc. So there you see also the format, and as the court decides upon a request from a party, already the request should be drafted the way how this is suggested in the guidances. That was an interesting part of the preparatory work, but also quite intensive regarding the amount of work. And now I'm back to my locations. Thank you very much. Yes.